Morning.
Hi.
Hi. My name is, actually, good afternoon. My name is Sujit Choudhry, and I'm counsel for the CCF, for the record. Ms. Jacques, I want to take you to the issue of the freezing the accounts. I know that we've talked a lot about that today. I want to invite you to answer some questions about lessons learned from that process and experience, which I take it was fairly unprecedented in Canadian history, because part of the Commissioner's mandate is to advise governments in the future about if and how to use these tools and how they might be adjusted. So if we could just do that for a minute. So you've heard that for some individuals, and we've had testimony to that effect, that because their accounts were frozen, they weren't able to meet their basic necessities. It might be child support, rent, food. In one case, we had a witness testify that he couldn't buy heart medication for his son, and I think we can all agree that was not the intent of the order. And so I want to put to you this question that you've said, listen, whatever the order said on its face, when we provided advice to financial institutions about how to administer it, we asked that they use discretion. But wouldn't it have been better to put a humanitarian exception into the terms of the order itself to ensure there was crystal clarity, not just to those institutions, but to members of the public who could have looked at the order online but would not have had access to that advice provided to banks and credit unions, that in fact they had that right to obtain monies that they needed to obtain monies that they required to meet their basic needs?
Certainly, I mean, looking at it, one of the key points that we did look at the outset when drafting, and you must understand we were working on this fairly quickly, looking at a de minimis amount, but we also understand that a number of people were donating small amounts to crowdfunding platforms, right? And so there was always that possibility. But looking at it, if we should do it, I think we could craft some exemptions for the application for very specific cases. It's not something that we did in the time that we had, but I don't disagree with you that it's something, in hindsight, that we could look at in being more specific in that regards. Because the intent was not to unduly affect, payments of child support or other payments.
Thank you. And maybe a broader question on the same theme or on a related theme to the panel as a whole, which is about consumer credit. And so I think the panel would agree that credit histories and credit scores, although kind of privately administered, are an important form of social and economic capital that citizens have. They require those scores to get credit cards, to get mortgages, to get loans, and so forth. And there's been evidence that you might not have heard, but I'll ask you to take my word for it, that some individuals who had their accounts seized and subsequently those accounts were released to them, nonetheless have had lingering effects on their credit history because of missed payments. And that might not be an effect. And so to your point, Mr. Sabia, that the Act was only used for a limited time period, that might be true, but the lingering effects of a decline in someone's credit history or credit score could take place or be experienced over many months or many years. And should there not have been some thought and some aspect of the order that would have taken into account the long-term effects on individuals' credit histories and credit scores by the temporary freezing of their accounts, even if only for a short time?
But you're talking about people here that were involved in unlawful activities.
Well, ma'am, that's not true. I mean, I think you've just said yourself that it was donors.
To our knowledge, no donors were affected by this, the order.
There were no accounts frozen. To the best of our knowledge, based on the information that we've received, there were no accounts from donors that were frozen.
And the long-term effects on credit histories, that's not something that concerns you at all?
I think that's an issue for, I think that's an issue for the financial institutions and how the financial institutions administer these things. I don't think that's something that that is in the ambit of the government of Canada. I think that's something that, as you know, in how the credit system works, that's something that the credit system should be able to deal with on its own.
Yeah, and so, Mr. Sabia, I'd put to you that although it's correct that it's a privately administered system, nonetheless, in this case, decisions of the government of Canada had a direct effect on how that system operated, not just in the short term, but for many months and potentially for long after.
Well, I guess I would dispute that. I think the government of Canada made some decisions with respect to the cessation of financial services, the freezing of accounts, to individuals who were involved in illegal activities. And all that those individuals had to do was to leave. And let's back up a little bit. The government announced its intention to proclaim or to invoke the Emergencies Act on the 14th. It was very clear as of that date, and the Minister of Finance was very clear as of that date, that people involved in these disruptions ran the risk of having their accounts frozen. That was very clear. So there was a period of notice there, and it was very clear that all that had to happen was for those people to leave, and as if they did, their accounts would never have been frozen, or that they would be immediately unfrozen if they did leave. So I think people had reasonable notice, and it was a very simple solution. All you had to do was leave.
Sure, and Mr. Sabia, I just put to you one final point on this theme, which is that the way you're describing the consequence on a credit score, it seems to me that you would agree with me that that's yet another economic incentive that individuals might weigh.
Yeah, well, that was never in our minds. That was never part of the intent of what we were trying to do, because honestly, I think that the credit system itself ought to be agile enough that those kinds of outcomes not happen.
Sure, and I'd say to Mr. Sabia, suggest to you that if that had been an intended consequence, that would be a form of extra legal sanction that went beyond the penalties in the orders.
But it wasn't any part of our intent ever.
Could I take you to the issue of crowdfunding and the regulation of crowdfunding? And so I know that one of the many issues on your agenda during the period leading up to the invocation of the Emergencies Act was the question of the available legal tools to curtail the flow of funds towards protesters participating in the various blockades. And I recognize you're not lawyers, and I'm sorry to have to ask you these legal questions.
Isabelle's a lawyer.
Oh, Ms. Jacques, well, it might be that you are going to answer some of these questions, but I put them to the whole panel.
Probably shouldn't.
And so what I'd like to do, if I may, if I could call Mr. Clerk to call up the following witness statement or interview summary for this panel, and it's WTS many zeros 59, page 7.
Someday you'll have to explain to us who comes up with this classification system.
I think council would like an explanation too, Mr. Sabia. So if we could just scroll down a bit, there we go. Thank you. So there are these two paragraphs here that I'd like to put to you for the record. And so the first paragraph is the one that begins, finance also looked to options under what, let's call it the money laundering and terrorism finance statute. And would you agree that it says there that Deputy Minister Sabia and Assistant Deputy Minister Jacques stated that it quickly became clear that there was a gap in the Money Laundering and Terrorism Finance Act. It did not apply to crowdfunding services. It applied only to certain payment service providers, and this was significant and so forth. You agree, and you agree you said that in the interview. And then if I could take it to the next paragraph, again, for the record, would you agree that you then added, Deputy, that an overriding issue with the options considered by Finance was timing, and any legislative amendments would take a long time to pass, whereas action was needed quickly?
Yes.
You said that, okay. And so...
And I said that this morning.
Sure.
Or this afternoon.
You did. I think you said it both, this morning and this afternoon. So you don't quite say it this way, but let me just put this to you. Are you saying there that the only way that you saw or that you were advised to get the money laundering and terrorism finance legislation to apply to crowdfunding absent using the Emergencies Act was a legislative amendment, and that just was not viable at the time?
Well, look, the gap here, that crowdfunding and payment processes were not in the ambit of FinTrack. This was something that people in finance that had been aware of for some time. This was not a revelation. The issue here, so you got to separate two things. On the one hand, this gap needed to be corrected, just because with the rise in importance of crowdfunding, et cetera, this was an obvious oversight. And it was the department's intention to recommend to the government that this be fixed, and it would have been in the traditional way that you would go about adjusting something like this. So that was in a, let's call it a steady state world. So in this circumstance, obviously we were not in a steady state world. And our intention here was to move as quickly as we could to try to correct this gap. And given the decision of the government to move in the direction of the Emergencies Act, that created an opportunity to address the specific case. But please note that in what we did here, we only applied it to crowdfunding platforms and payment processors who were in some control of assets or capital or financing that may be associated with these, quote, illegal activities as declared by the Emergencies Act. So it was quite limited. And it was only in place for, what, a period of 6 or 7 days. We then, this issue having been resolved, returned to the more status quo kind of approach, and we did correct this in the April budget. I think we did it in the...
So via regulations.
Yeah, okay.
So can I just pick up, though, on something you said? So you kind of drew a distinction between, let's call it government as usual or normal, and the urgent situation that was thrust upon you in early February. And so in the government as normal approach, what you say here is that there would need to be a legislative amendment. But that's not the moment that Canada was in at that time, you say. There was no time for a legislative amendment to amend. Well,
a legislative amendment or even a regulatory change, because they too take. So
you've anticipated my next question. So look, I want to take you to the following document. It's CCF many zeros 42. Thank you, Mr. Registrar. If you could scroll down. So if we could stop there, actually, sorry. You can see this is an amendment to the regulations in relation to the money laundering and terrorism finance statute. It was promulgated on April 5th by the Governor and Council. And as you know, the Governor and Council just does that. There's no legislative process involved there. And then if you could scroll down, please, to section 2. And so here, let's, if it could go, yes, actually, that's right. the regulations are amended by adding the following before Section 30. It says, for the paragraphs of subparagraphs 5HV and H.1V of the Act, crowdfunding platform services are a prescribed service. So I'd put to you that what this regulation did was to extend FINTRAC's authority and the application of FINTRAC to fund crowdfunding services. Would you agree?
Yes.
But this could have been done just as easily in early or mid-February.
Yeah, not just as easily.
Why is
That's
that?
because the regulatory process, there are several steps to it. It is quicker, you are correct, than in typical circumstances than the legislative process, but there are a number of steps involved.
But Minister, sorry, Deputy Minister.
Yeah, big difference.
Sorry, excuse me. But I take you, if you'd like, I can take you to the terrorism financing legislation itself, but we don't have time. But I'd put to you this, that there's nothing there in Section 73 sub 1 or 73.1 sub 1 that spell out a lengthy, detailed regulatory process. It might be that that is what normally is done, but as a matter of law, that's not required. And so if that's true, then couldn't the government, couldn't the federal cabinet just have enacted this regulation in February?
Yeah, but I fail to see, given how narrowly the Emergencies Act was used here, in applying it only in a very, very narrow slice of crowdfunding platforms and payment processors, I fail to see how there's really a meaningful distinction. And importantly, that very narrow change was only in place for 6 or 7 days. And we then corrected it later as per this process. So I think we're kind of both on the same page.
Well, Deputy Minister, let me just conclude by explaining to what we see the differences being and put it to you. So I take it you've read the Emergencies Act and you've read Section 3 of the Act?
Yes.
And Section 3 has at the end of it a last resort clause. It says that the Emergencies Act can only be triggered as a last resort if no other legal tools are available and are effective. And I'd put to you that this shows that in relation to FINTRAC, there was another option available to the federal government, absent or short of declaring an emergency. Jacques, I can see you want
Yeah,
to
I do not want to reply for Michael, but we could have never drafted and passed those regulations and those timelines.
But Ms. Jacques, all that's required here is a one-paragraph amendment to the existing regulations. These are shorter than the amendments, than the terms of the economic measures order.
It seems very simple because, you see the drafting of the amendments, it doesn't seem to be very long, but the process to pass a regulation, it's not something that you can do in the timelines we had to enact and work on the order.
Commissioner, I think those conclude my questions. Thank you.
Okay, so I think this is the time for the lunch break. So we'll take a lunch break and come back at 2 o'clock.